Once you know that somebody wrote down some symbols and ended up in jail for it, you're immediately going to think twice as to whether you're going to write something down yourself. And so the chilling effect of overzealous policing of the publication of ideas, whether they're software or novels or political treatises, really does rapidly devolve into the slippery slope.
When is code speech and deserving of protection under the First Amendment? It's something the U.S. Supreme Court has yet to definitively answer, and I spoke about it at length with Pieper van Valkenburgh, Executive Director at Coin Center, whom you just heard from. Peter's one of the 6 experts who contributed to this episode on software and free speech. Now, this episode covers cryptography, cryptocurrency, and AI, because each raises the question of when code transforms from protected speech into something that falls outside the scope of the First Amendment. Now, it's difficult to overstate the importance of the First Amendment. I think Jane Bambauer, a law professor at the University of Florida and a First Amendment scholar, does a good job explaining why this matters in the next clip.
The most inviolable part of each person, I think, has to be our mind. And so if the government is indirectly controlling what we get to learn and what we get to read and see, and yes, even data, even boring bits of information, then it is doing something that has a form of control that gets right to the root of each person. And so I approach First Amendment questions with that assumption that one of the core, not the only one, but the core purpose of the First Amendment is to protect free inquiry and freedom to develop knowledge.
Now, how the First Amendment applies to code is important not just for Americans, but for anyone in the world who wants access to the latest tech, because while other countries might not have the First Amendment protections, their citizens benefit from them. A good example is the impact these protections have on what Americans can produce and export. We saw that firsthand in June of 2026, when the U.S. Commerce Department issued an export control directive to Anthropic, the makers of Claude, requiring the company to obtain a license before allowing any foreign person, even if employed and resident in the United States, access to its most advanced AI models. Anthropic immediately disabled the models for all users worldwide. And I spoke about this with Sam Enzer, a litigation partner at the law firm Cahill Gordon Reindel, which I'm so grateful to have as a sponsor of this episode, and co-chair of CahillNXT, Cahill's digital assets focused practice group, who explains more on that situation now.
To take a step back, I think you have to look at what was it that Commerce did. So we now know, we did not know on that Friday evening, but more has surfaced through public reporting. And according to the public reports, the facts of what happened are the Commerce Department or the government, the Trump administration, received reports of concerns from Amazon, an investor in Anthropic. And the concern that they raised was that Fable 5, Mythos 5 had a so-called jailbreak that enabled users to effectively turn these powerful models into tools that could be used to commit hacks, exploits, to breach cybersecurity for a variety of different platforms, that this raised national security concerns, and thus the government should intervene, which the government did. It sent what's called an is-informed letter, a letter invoking the export restriction powers to say this technology seems like it could be what's called dual use, meaning commercial or military use, cybersecurity being the dual in that. And we hereby restrict you in light of the national security concerns that this presents from exporting it to anyone who's a foreigner. And effectively, there was no way for Anthropic to do that in timely fashion, so they cut off access.
That access was restored when the U.S. government lifted the directive about 2 weeks and a lawsuit later. The lawsuit was from Legion Legal Tech Corp., a legal tech company that relies on Anthropic's models. They're based in San Jose, but they have employees in Canada as well. And when they weren't able to access the latest models of Claude, they filed a lawsuit against the U.S. government. Here's Sam Enzer to explain more.
This lawsuit invokes, among other statutes, the Administrative Procedure Act. In a nutshell, the lawsuit is a challenge by effectively a user, a business user of Anthropic's model, who says, look, we have technology, a legal service that relies on Anthropic's model. We relied on it. We had to stop using it because the government intervened and told Anthropic that they could not export that model to any foreigners. under the government's export restriction powers. And we think, this is what the lawsuit is saying, we think that this exceeds the agency's powers under statute, that they don't have the power to do this, and that this was not done through notice and comment rulemaking, which is how agencies should act. Instead, this was effectively a ban on a piece of software that people access through the web in a manner that was arbitrary and capricious and should be struck down. That's the premise of the lawsuit.
So the lawsuit from that company was ended after the directive was dropped by the government. And the government, particularly in the US, has run a familiar playbook there, as export bans on code had been implemented and lifted before, also after a lawsuit. The famous example of that came in 1995 when an American mathematician named Dan Bernstein sued the US government for restricting him from publishing an encryption algorithm called Snuffle. His lawsuit claimed that export controls on cryptography were unconstitutional as an impermissible prior restraint on speech in violation of the First Amendment. So while today's technology is different than the cryptography that raised First Amendment concerns in the 90s, the battleground is very familiar. Welcome to the Law of Code podcast. I'm Jacob Robinson, and my goal is by the end of this podcast, you'll understand the history of the government's attempts to limit code, how free speech arguments forced them to backpedal, what's happening with AI and crypto today, and where the line exists between code that's protected and code that's capable of being regulated. You don't need to be a lawyer to follow along. We'll explain all the jargon throughout. That said, this should be the best legal podcast you've ever listened to. That's the standard with every episode I publish. If it's not, you'll get your money back. That's a bad joke. This podcast will have a bunch of that as well. Thankfully, this is a free podcast, thanks in part to the presenting sponsor of this episode, Altitude. Now, in a few minutes, you'll hear the full interview I did with Pieper, who has testified before Congress multiple times. But first, something he mentioned in a prior interview was a veto right that bad actors would have over good technologies if governments have the ability to constrain open source code because of its use by bad actors. Here's Pieper from that other episode.
No one would want to publish anything that is of particularly good use because, of course, the best tools are going to be used by bad people. In fact, bad people are more likely to use really good tools than good people because they don't have the backstop of a contract and legal system behind them when things break. So they need their tools not to break. They need their tools to work really well. And so if you set up a legal standard that says developers of software, if they have even an inkling that their tools will be used in the future for bad things, then they can be ultimately culpable when those tools are used for bad things. You're basically giving the worst people in the world, the criminals and the terrorists, a veto right on good people developing good technologies for ordinary uses.
Thankfully, the First Amendment, as well as Dan Bernstein's lawsuit and the work of many, many others in this space, put enough pressure on the government to change the rules. So encryption now protects our online transactions. We can buy things and conduct business online with confidence. One of my prior guests, Stepan Simkin, who I interviewed in episode 39, is adding to the benefits we get from transacting online by building Altitude, a global operating account built on stablecoin infrastructure. Altitude is the presenting sponsor of this episode because they wanted to support these conversations and because I thought you'd benefit from knowing about their product. About a month ago, I was speaking with a lawyer who I work with. He mentioned he was referring his clients to Altitude, and he doesn't have a podcast, because they offer the best product for businesses that transact in both fiat and stablecoins globally. Altitude allows businesses to operate in US dollars and euro from anywhere in the world, move money globally in seconds for free with stablecoins from a single global account. So even if a business has multiple entities across jurisdictions, which I saw often in private practice, the payment flows all sit in one account. Stablecoins make this possible, though Altitude also offers access to ACH, SWIFT, and SEPA for euros, plus other rails for businesses in 150 plus countries. So if you have any clients looking for a better financial operating system that pays them to use it, visit altitude.xyz/law. And if you book a demo, you and any of your clients that you refer get white glove and priority onboarding. I'll also try to join your call with Altitude because I like you and we don't see each other enough. Now, as I was saying, this podcast is about the line between protected expression and functional code. It's a blurry one, but an important one. There's a reason speech is in the First Amendment, after all. Now, it's probably a good time to actually read the First Amendment before we dive into this whole episode. Quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances." Unquote. Now, Professor Eugene Volokh was a longtime professor and is currently a fellow at the Hoover Institution at Stanford University. He has spent decades writing about the First Amendment and is often cited by Supreme Court justices in their decisions. I asked Eugene about his philosophy of the First Amendment.
I want to mention two things that probably come closest to philosophies. One is, I think the rule that we need to keep in mind when we think about free speech controversies is, if there's a proposed speech restriction, what will we think about it if it's being deployed by people we don't like, people we don't trust? If you are, let's say, a traditional Democrat, the question isn't, well, if there was a First Amendment rule that allowed certain restrictions, what would the Obama administration do with it in the past? It's, what would a Trump administration do with it? What would a J.D. Vance administration do with it? Some of the time, of course, your people will be in power and you'll trust them and you'll think that they're going to do a fair-minded job of applying the rules. But some of the time, people you don't like at all will be in power. And by the way, of course, if you're a conservative, likewise, the question isn't just, well, what would Trump or Vance do with something if you like them? It's also, well, what would a Newsom or Ocasio-Cortez administration or some such do with them? So I do think that that's a very important principle. It's important principles to all legal rules. But it is particularly important when it comes to free speech because restrictions on speech can affect who the next administration is going to be, can affect the ability to change, to change our political system. And I do think it's really important for people to recognize that the question isn't just how will they be used in good faith, but also how will they be used in bad faith. The other thing, though, to keep in mind, much as I believe in pretty strong free speech protection, is that the world is a complicated place, and speech is a complicated phenomenon. And there are all sorts of different rules that can't be captured in one line. There's protection for all speech. Well, it's not all speech. Or protection against viewpoint-based restrictions. Well, that's a bit more precise, but there are some kinds of viewpoint-based restrictions that are permissible under certain circumstances. So the world is a complicated place, and legal rules often end up being complicated as well.
Now, as was pretty clear to me while doing this episode, the First Amendment protections are among the most complicated of these rules, covering the most controversial aspects of American life. Code can be protected speech in some contexts and not in others. Where that line exists is a question we don't have a definitive answer to, either in the Constitution or the Supreme Court. Here's Eugene Volokh again to explain where some courts have found that distinction to sit.
So machine code could be used to communicate, but it also does things. So that's why courts have said that when code is regulated because of its functional qualities, because of what it does, then in that case, either there may be an argument there's no First Amendment protection, especially when we're talking about object code, but even for source code, even if there is in theory some First Amendment protection, in fact, when it's being regulated because of its functionality, the government has a lot of leverage.
Eugene also gave an example that illustrates his thought on that line, the distinction between speech and function, because there does have to be one.
So let me start with a slightly different perspective. It's an analogy. It's not completely perfectly the same. That's why it's an analogy. But I hope it's helpful in part because it's not something people usually think about. Sculpture. Is sculpture protected speech? The answer is pretty clearly yes. It's always been assumed to be that. In fact, it's actually one of the earliest of the art forms. One of the oldest, let's say, at least, of the art forms. There's no, I think, Supreme Court case that's squarely on point, but it's certainly understood if the city were to say, oh, we don't like your sculpture because it conveys some bad ideas, you have to take it down. Well, generally speaking, especially if it's on your own private property, would be clearly unconstitutional. All right, how about sculptures made out of metal with all sorts of little metal parts in them? Sure, sculpture's protected whether it's marble or metal. Can sculptures convey not just ideas but information? Well, yes. For example, you could imagine a sculpture that depicts something, maybe a model of let's say, an ancient warship that conveys much more effectively than words information on what it looked like. And if somebody were to say, no, we just don't like you conveying that information, well, then, of course, the First Amendment would step in to protect against those kinds of restrictions. Let's say somebody says, okay, I have created this sculpture, and it is a sculpture that is a very accurate copy of a fully automatic weapon, of a machine gun. I think it is aesthetically quite pleasing. I think it also conveys important information to fellow gunsmiths about just exactly how a machine gun would work. Now, to be sure, machine guns are not protected by the Second Amendment. The Supreme Court has said that. Guns generally are protected, but machine guns are not. But you say it's protected by the First Amendment. It's just a sculpture. I should be able to sell copies of this sculpture to my fellow machine gun sculpture aficionados. Dickon would say, we don't think that's right. We don't think that's right. And not because just there's a compelling interest in preventing distribution of machine guns. Rather, it's because this thing may have an aesthetic quality, may have an informational quality, but also has a functional quality. Functional quality of machine gun is if you feed the rounds in it the right way, if you pull the trigger, a whole bunch of them will shoot out the front towards the target. And when bans on machine guns or regulations of machine guns restrict that, they're restricting this functional quality. We don't think they should be judged under the First Amendment, even though a machine gun is, in some respects, similar to a metal sculpture. And even if it is judged by the First Amendment, surely the fact that it's being restricted not because of what it communicates, but because of what it does, is a very important factor in favor of upholding. So far, I hope people agree. Now, I know lots of my friends are big gun rights enthusiasts, and they may think that, in fact, the Second Amendment should protect machine guns. But I think even they would say, okay, that's a Second Amendment question. The First Amendment, it's about freedom of speech, doesn't necessarily include the right to produce things that are functionally usable in the real world that the government wants to regulate because of their functional utility. Well, in many ways, that same thing is true, I think, of computer code. That computer code does indeed convey information to people, but it also does things. So that's why courts have said that when code is regulated because of its functional qualities, because of what it does, then in that case, either there may be an argument there's no First Amendment protection, especially when we're talking about object code, but even for source code, even if there is in theory some First Amendment protection, in fact, when it's being regulated because of its functionality, the government has a lot of latitude. So let's just take one thing that's much talked about is agentic AI. So let's say you have AI agents running and doing bad things. And let's say I say, here is an agent you should run. It'll break into all of these computers and crash them and such, but you should run it. And here's the code. Just run it. Just enter it into whatever platform you have and hit enter. That seems to me to be basically a functional use of the code, as opposed to, say, an article that says, here is how we might write various kinds of things, which may be a non-functional use. Conversely, if you look at not just the use of the code by the user, but the way that the code is being regulated by the government, is if the government just says, well, you can't distribute this kind of information because we think it's dangerous information, it's one thing. On the other hand, if it says you can't distribute something that you can enter into a computer, just copy paste into a computer, and it would have this following result or following effect because of not what it communicates, but what it does when it's fed into a computer, that is probably a restriction that would be constitutionally permissible.
Now, as Eugene mentioned, computer code can do things. One of the things it can do is obfuscate transactions on the blockchain, in the case of, say, Tornado Cash software, which allows people to send cryptocurrency privately. Should the publishing of that software be protected speech under the First Amendment? What happens when someone uses that code to, say, send cryptocurrency? What if that code displaced an intermediary like a bank, which has long been regulated? These are complex policy questions that I spoke at length about with Peter van Valkenburgh of Coin Center, who co-authored a paper titled Software is Speech. That's where my conversation starts with Peter, as he explains who's actually being targeted when people are using this open source, published, often immutable code to make transactions online.
It's not going to be software in the abstract. We saw how that went with the Tornado Cash sanctions. It's going to be the person who wrote the software, even though that person is not at all a banker. They're a technologist. And even though you'll basically be forcing them to completely change the nature of what they're doing, it'd be like asking J.K. Rowling to keep track of all the people who read her books. She's no longer a publisher. She's like some sort of weird entertainment interactive service provider.
And that's the end of Harry Potter.
which maybe is fine. I don't know. It's very contentious these days. I was never a Potter fan, but I definitely don't want that to be the end of open source software, because so much of the economic boom of the 90s, 2000s, 2010s, and our newfound sort of freedom of expression and liberty online is based on this widely available open source software stack that is the free and open internet, which is always in jeopardy, either from corporate interests or from government interests.
Now, for more on specifically what Peter's talking about there, developer liability and unlicensed money transmission, we covered that at length in episode 200 of Law of Code. But there's an important distinction, and one we didn't get into too much in that episode. There's the idea of open source software, which Peter is talking about there, and what Eugene was talking about in his machine gun sculpture example. On one hand, there's publishing open source software. But now, what if someone uses that open source software while providing a tool that allows someone to break the law? It's a difficult line. Here's Peter to share more on that point.
If you look at the legal academic writing on the First Amendment right now, you'll see a lot of credence given to this notion that when speech in the software context is sufficiently useful, sufficiently close to being executed, and by close to being executed, they mean like it's really just machine code. It's really just the instructions for the machine. It's not the comments along with the code that explain to some other developer how to use the code or how to think about the code. That when it's utilitarian in that sense, it somehow falls into a lower bracket of First Amendment protections. And we go through in the paper, Laz and I, Laz is the director of research at Coin Center.
Shout out to Laz.
Big shout out to Laz.
Big shout out.
Co-authors on this paper. And he did fantastic work. We go through in depth the sort of emergence of this functional theory of lesser protected speech. And I don't think it has been clearly articulated in a lot of the other legal literature that this is an emergent strain of First Amendment jurisprudence that actually has zero root in either the text of the First Amendment or any Supreme Court precedent. It's purely a lower court phenomena, and it only exists in this area of software and encryption. And so the early cases there are some that maybe some of your regular listeners will be familiar with, like U.S. v. Bernstein, where you have an academic professor who wants to publish the source code for encryption, strong encryption algorithms, and the U.S. government says you can't publish this. This is a weapon of war. It's a munition, and our export control laws forbid you from publishing this because it will fall into the hands of the enemy. And that was a formative early case where the courts had to grapple with whether publishing software is the same as publishing a novel, and whether you can therefore be restrained from publishing prior restraint. So not after the fact consequences for publishing, like you wrote something defamatory, you wrote something untrue, so therefore we're going to punish you, but just ex ante, punishment where if you publish this at all without us reviewing it and giving you the okay, you're going to be in trouble. And the courts there were actually largely right. This is a Ninth Circuit case. They said, look, it's still speech. We're not going to be able to delineate between, mathematical formula, which a great mathematician might publish, and RSA, the fundamental algorithms behind strong encryption at the time. And so therefore, we're not going to say this isn't speech. However, and the court notes this, it's sort of dicta. It's like a background discussion in the holdings. It is notable that this speech instantly can become conduct. And what they mean by that is, yes, a foreign adversary could, as soon as they get a hold of the open source code for RSA, start using strong encryption to keep secrets from the U.S. government, the U.S. Army, or their enemies. And that has very real repercussions. Now, to me, the right way for that to have entered the judicial standards would be in the strict scrutiny test. For once we decide that what we're dealing with and thinking about restricting is speech and worthy of First Amendment protection, that means the regulation gets strict scrutiny. It doesn't mean automatically that the regulation is unconstitutional. It just means that the government needs to meet a very high bar to justify the regulation because there's an extremely powerful government interest at stake here. And the only way to affect that interest, to get that interest, is this minimally constrained restriction.
I want to interrupt Peter and pause for a second, and I'll do that throughout this episode because I think the background here is really, really important. To understand how we got here, we have to go back in time. And since I refuse to implement any cool sounding back in time gimmick for this podcast, we'll instead travel back after a brief legal disclaimer. It's not as fun, but hey, I'm trying to be a professional here.
Anything mentioned in this episode by Jacob Robinson or his guests is not legal advice or investment advice. All opinions are Jacob's and his guests alone. This show is solely for information and entertainment purposes only. Jacob and his guests are not your lawyers, nor are they investment advisors.
Now, with the advent of the Cold War in the late 1940s and early 1950s, the end of World War II, all the NATO countries agreed to restrict the export of tech and weapons to the Soviet bloc. Among the list of controlled items were nuclear reactor components, guided missiles, and cryptography, which made a lot of sense. Cryptography at the time was used almost exclusively by governments and militaries for sending encrypted messages and decoding enemies' messages. One historian actually estimated that the advantage the Allies had from breaking German and Japanese code shortened World War II by almost 2 years. This advantage was critical, and of course they wanted to maintain it. So the US government enacted a host of laws to do that. The Export Control Act, the Atomic Energy Act, the Mutual Security Act, and many others. This set of rules becomes the core of the government's model that includes the munitions list, which is the government's official catalog of weapons. Cryptography was on that munitions list, which made encryption software regulated by the same rulebook as missiles and fighter jets. That's why U.S. Customs opened a criminal investigation into American software engineer and cryptographer Phil Zimmermann for arms trafficking. Phil had created an encryption program in the 90s that gave ordinary people access to military-grade cryptography for their email and files. It was called PGP, or Pretty Good Privacy. Now, because encryption above a certain strength was a munition under ITAR, which is the government rules that applied here, the government took the position that posting it, so posting the encryption where foreigners could download it, was an illegal arms export. Again, just publishing this code, this PGP, Pretty Good Privacy, was an illegal arms export. You see, before PGP, strong encryption was effectively the exclusive domain of governments, militaries, and large institutions. And here's an interview that Phil Zimmermann, the creator of PGP, actually did in 2001 while I was probably watching Batman cartoons or maybe even dressed as Batman, about the state of cryptography and secure communications at the time. Remember, this is in 2001. He's talking about when he published PGP, which was around 1993, I believe.
What was the state of cryptography before PGP? Was it crackable? I mean, was the government able to break into this stuff?
Before PGP, there was no way for two ordinary people to communicate securely over long distances.
The NSA or the FBI or the CIA could eventually unencrypt that data. Basically.
Yeah. The strongest crypto software you could get at that time had the 56-bit DES as the algorithm, and that's very easy for them to break.
A couple of minutes for a big NSA supercomputer.
Yeah. So yeah, there really wasn't any privacy in the digital space at the time. And while Phil Zimmermann was under investigation, he actually worked with MIT Press to publish the complete PGP source code as a physical book in 1995. The book was printed in a special font so anyone could scan it and compile the working program. He was taking advantage of what seemed to be a contradiction in the law. You see, in the US, books are protected by the First Amendment. This made them exempt from ITAR, again, which is the rules that applied here, as published material. So identical code was legal on paper and a felony on a floppy disk. That was because the relevant definition of, quote, controlled technical data, which was governed under ITAR here, explicitly excluded general scientific and mathematical principles that were commonly taught in universities, any information that was in the public domain, meaning anything published and generally accessible to the public through bookstores or libraries or other areas was fair game. Now, in January 1996, with Zimmermann's book published, the Justice Department actually dropped the investigation without charges or explanation. It was a situation that raised important policy issues that again surfaced in the Bernstein case. I want to talk about that case really quickly now. While he was a graduate student at UC Berkeley, Bernstein wrote an encryption algorithm called Snuffle. He wanted to publish it and speak about it with other cryptographers and anyone who'd be interested. But because encryption software was again on the United States munitions list, Bernstein needed to register as an arms dealer and apply for an export license before he could even post his research online. He went to the State Department and asked whether he needed a license. They said, yes, Bernstein, you need a license. So he said, okay, well, thanks, guys. Can I get one? And they said, no. If you apply, we're going to deny you because your encryption was too strong. So you need a license, but we won't give you one. And therefore, you can't publish any material on Snuffle, which is your new encryption software. That would make me mad. It's kind of making me mad now. It also made the team at the Electronic Frontier Foundation, the EFF, mad. So in February of 1995, the EFF sued the US government on behalf of Bernstein, arguing that not only did these regulations chill the speech of individuals like Bernstein, they also hampered American businesses by limiting the export of encryption technologies and methods. Because remember, now these businesses can't securely transact online without potentially being intercepted by the US government or foreign governments. Now, the Bernstein case really set a foundation for the internet as we know it today. That case began in the Northern District Court of California, which is the trial court, the entry point for federal litigation, where Judge Marilyn Hall Patel issued the crucial first ruling, at least that I could find, that found that code is speech and so protected by the First Amendment. Quote, this court can find no meaningful difference between computer language and German or French. Like music and mathematical equations, computer language is just that, language, and it communicates information either to a computer or to those who can read it, unquote. That was in April of 1996. Prior to Judge Patel's decision, no court had formalized that principle that code can be speech in a ruling, or at least any ruling I could find. The Bernstein decision helped ensure the security of activities like online banking and shopping, and its recognition of code as speech helped build the legal foundation for the recognition of online rights. Now, let's go back to my conversation with Peter, and he was talking about the Bernstein case, which the government lost in the district court, which was appealed to the Ninth Circuit Court. And Peter's talking now about what the Ninth Circuit Court said on software as speech.
They said, look, it's still speech. We're not going to be able to delineate between, mathematical formula, which a great mathematician might publish, and RSA, the fundamental algorithms behind strong encryption at the time. And so therefore, we're not going to say this isn't speech. However, and the court notes this, it's sort of dicta. It's like a background discussion in the holdings. It is notable that this speech instantly can become conduct. And what they mean by that is, yes, a foreign adversary could, as soon as they get a hold of the open source code for RSA, start using strong encryption to keep secrets from the US government, the US Army, or, their enemies. And that has very real repercussions. Now, to me, the right way for that to have entered the judicial standards would be in the strict scrutiny test. For once we decide that what we're dealing with and thinking about restricting is speech and worthy of First Amendment protection, that means the regulation gets strict scrutiny. It doesn't mean automatically that the regulation is unconstitutional. It just means that the government needs to meet a very high bar to justify the regulation because there's an extremely powerful government interest at stake here. And the only way to affect that interest, to get that interest, is this minimally constrained restriction.
Another important takeaway from this case for our purposes here is the narrowness that the Ninth Circuit panel, which ruled in favor of Bernstein 2-1, emphasized. Here's a quote from that decision. Quote, "We do not hold that all software is expressive. Much of it surely is not. We hold merely that because the pre-publication licensing regime challenged here applies directly to scientific expression, vests boundless discretion in government officials, and lacks adequate procedural safeguards, it constitutes an impermissible prior restraint on speech," unquote. They also wrote that, quote, "To the extent the government's efforts are aimed at interdicting the flow of scientific ideas, whether expressed in source code or otherwise, as distinguished from encryption products, those efforts would appear to strike deep into the heartland of the First Amendment, unquote. Now, while Peter was talking, one thing he mentioned was the strict scrutiny test. It's one of 3 standards of judicial review in U.S. constitutional law. It's very, very relevant here because courts use strict scrutiny when a law does one of 2 things. It either burdens a fundamental right, like free speech, or discriminates based on a suspect classification, like, say, race. I asked Sam Enzer, a partner at the law firm Cahill, which again is a sponsor of this podcast, about whether free speech arguments will be implicated in a future case involving AI.
It's a great point, and I'm glad you raised it. So the First Amendment holds a special place in the hearts of Cahill lawyers because a Cahill partner who still works at the firm, he's retired, but he still works as senior counsel, Floyd Abrams, is widely considered to be the godfather of First Amendment litigation. So in the 1970s, when the New York Times wanted to publish the Pentagon Papers, he took the case at Cahill, represented the New York Times against the Nixon administration, which did not want the Pentagon Papers to be released, won and secured a Supreme Court victory in that case. And we have, as a firm, for years, long before AI was on the tips of everyone's tongues, we were handling First Amendment litigations for AI companies, including Clearview AI and others, on First Amendment grounds, making arguments about why code is speech, about how software can be used in a manner that is to create marketplaces or exchanges of ideas, the very core things that the First Amendment is designed to protect. So the First Amendment is a very important restriction on government power in the context of software and in the context of how AI can be used. And I think it is important that we think about it, discuss it. Now, the First Amendment, although it says, it reads as an outright prohibition on restrictions on speech, the way the Supreme Court in the United States applies that restriction is a little more nuanced than that. Basically, depending on the type of speech or conduct involved, government law can restrict speech, but it has to survive various layers of scrutiny: strict scrutiny, intermediate scrutiny, or rational basis scrutiny, depending on the type of speech involved. So, for example, in the context of strict scrutiny, you could have a law that restricts speech, but it's going to have to be narrowly tailored and have a compelling justification. Now, of course, one of the most compelling justifications the government can have is when national security is at play.
So Sam explained how strict scrutiny would play a role here. To survive strict scrutiny, the government must prove 2 things. First, that the law serves a compelling government interest, like national security, as Sam mentioned. Second, that the law is narrowly tailored to achieve that interest, meaning that the law must actually advance that interest. It must be the least restrictive means available. So if there's less of a speech restrictive option available, the government must use it. It can't be over-inclusive, sweeping in more speech than necessary, and it can't be under-inclusive. It can't leave out conduct that causes the same harm, because that suggests the interest really isn't that compelling. Strict scrutiny is the most demanding standard of judicial review, and when it applies, the government typically loses. We'll go back to my conversation with Peter now, as he's about to explain why that should be the case for code.
To be clear, I still think most government regulations should fail the strict scrutiny test, because I think it would be an extraordinary circumstance where there'd be a compelling enough government interest to justify some sort of blanket licensing regime for any kind of speech.
Yeah.
But that is the right place to engage with that. Now, what was interesting is in the evolution of the First Amendment literature on software that grew out of the encryption cases like Bernstein. And the most interesting case here is probably Corley in the Second Circuit, started in the New York courts. In Corley, the court is dealing with software. It's actually CDs. It was a guy who was sharing CD-ROMs. Close to my heart. I grew up with the early internet and the early computing revolution, and I probably actually handled some CDs with this actual software on it.
From Corley.
From the software that was in debate in Corley.
Wow.
The software in that case was it was a tool to remove the digital rights management encryption from DVDs and music and like MP3s and things like that. And so, you'd buy your MP3 or you'd buy your DVD and you'd be like, well, I want to share this with my friend. I used to be able to copy VHS cassettes, so I'll just copy this DVD. And you'd use this software to strip the rights management encryption from it and then copy the unencrypted film to your friend. In that case, the Second Circuit Court of Appeals said, yeah, but here, this is not expressive software. This is highly utilitarian software, and its purpose, the thing that it helps you do, the thing that makes it utilitarian, is actually sort of an illegal purpose, or it's a purpose that in some clear way is antagonistic to our ideas of the copyright clause of the Constitution. So maybe we're actually balancing your right to free exchange of information, the First Amendment, with the copyright clause of the Constitution. We've got two constitutional principles at work here. And we're not going to do this analysis in the strict scrutiny area. Like, is this really a compelling government interest? And is this a narrowly tailored way to stop copyright infringement? We're going to do this analysis as a perfunctory analysis where we say, well, is this really speech at this point? Or is this actually more of a, non-expressive machine code for bad purposes? And so you end up with this value-laden test at the beginning of the First Amendment analysis where the court's starting to say, like, we can question whether something is even speech if it's software that's particularly utilitarian and particularly prone to being used for bad purposes and not good purposes. And I think to a lot of people that probably sounds reasonable, but if you're a First Amendment scholar, if you're someone who thinks about the free exchange of ideas a lot, you realize that that's actually an anathema to the First Amendment. Because the whole point of the First Amendment is that government officials, whether they're regulators or the police or Congress and the courts, shouldn't be in the business of deciding whether some page of text is sufficiently beautiful that it warrants protection, or is simply too bland and utilitarian, or is simply too subversive and therefore shouldn't be allowed. The point of the First Amendment is to say that's never the government's place to make that perfunctory call as to whether something is worthy of being shared. The purpose of the First Amendment is to say, no, the marketplace of ideas, the fact that an American will be exposed to all this. They'll get communist propaganda. They'll get socialist propaganda. They'll get capitalist propaganda. And the American is supposed to be able to get it all and be like an infovore and consume it all and come out better through the synergy of thinking about these things. The government shouldn't be playing a role as a censor. And so Corley, I think, got it fundamentally wrong in that it said, we're going to impose intermediate scrutiny rather than strict scrutiny on this regulation, because the underlying thing being regulated isn't actually speech in the pure sense. It's some sort of speech conduct hybrid for a bad purpose, and it's not expressive. And that case, Corley, has no grounding in past Supreme Court precedent.
Now, just to pause here for a second, because I want to share another key fact in Corley in a paragraph in the decision that I found pretty notable. Before I do, though, I asked Professor Volokh about which case in this regard was the most influential, and he referenced Corley.
I think probably the leading one, the one that I think has had the most influence. And, I can't vouch for it being entirely correct, but I think it sets forth at least an important structure, is a case called Universal City Studios versus Corley. It's a 2001 Second Circuit case. If you want this full citation, it's 273 F3rd 429. But I think if you just do a Google search, or especially go to Google Scholar and search for the case Universal City Studios versus Corley, you'll find it. And I think this had to do with the distribution of DCSS, which is a mechanism for breaking a certain kind of protection mechanism for copyrighted works. And the court there, I think, articulates this distinction between regulations that are motivated by the functional features of code, and those are motivated by the communicative features of code. And I think it's at least it's an important thing to look at for people who are interested.
In Corley, he wasn't stripping the DVDs of their encryption themselves and selling them. He also didn't create the software. He instead hosted a website that included a link that allowed someone to download the software. So the opposition, which was a group made up of movie studios, argued that Corley was offside the Digital Millennium Copyright Act, the DMCA. The movie studios got two injunctions, first prohibiting Corley from posting the decryption technology or any similar technology on any internet website, and second, knowingly linking any website that had this decryption technology in it. The district court, in ruling against Corley, actually created a test to use whether an injunction against hyperlinks could be granted. That test required clear and convincing evidence that those responsible for the link A knew at the relevant time that the offending material is on the linked site, B, know that its technology may not lawfully be offered, and C, create or maintain the link for the purpose of disseminating that technology. The district court found that the evidence satisfied that test, and that was part of the reason why they ruled against Corley. Corley appealed, and the appeals court acknowledged and agreed that both source code and object code deserved First Amendment protections. But they said this, and I think this is a really interesting and really important sort of paragraph that they use as a way to think through this. Quote, there was a time when copyright infringement could be dealt with quite adequately by focusing on the infringing act. If someone wished to make and sell high-quality but unauthorized copies of a copyrighted book, for example, the infringer needed a printing press. The copyright holder, once aware of the appearance of infringing copies, usually was able to trace the copies up the chain of distribution, find and prosecute the infringer, shut off the infringement at its source. So you'd go after the person who had the printing press, let's say. Now, they add that in principle, the digital world is very different. Once a decryption program is written, it quickly can be sent all over the world. Every recipient is capable not only of decrypting and perfectly copying copyrighted DVDs, but also of retransmitting perfect copies of the decryption software and thus enabling every recipient to do the same. So they use this analogy of the printing press in terms of how different it is. So it'd be like, imagine everyone having the printing press, which I'd argue we do now with printers, and they sort of contrast that with the ability to decrypt, which they considered an illegal activity in this case. So they talk about how the process is potentially exponential rather than linear. And I think, I don't think they got that perfectly right because there are, as I mentioned, the printer, and there's some differences here. And they get into sort of separating the speech component from the non-speech component here. Quote, the DMCA as applied in this case and the posting prohibition of the injunction target only the non-speech component. Neither the DMCA nor the posting prohibition is concerned with whatever capacity the decryption software might have for conveying information to a human being. The DMCA and the prohibition are applied solely because of its capacity to instruct a computer to decrypt the software. That functional capability is not speech within the meaning of the First Amendment, and that's the court in Corley. Since the court found that the prohibition was content neutral, they didn't actually apply that strict scrutiny standard. Court wrote that it is true that the government has alternative means of prohibiting unauthorized access to copyrighted materials. For example, and this is sort of where I think a lot of people in the crypto space are saying what they should be doing. For example, it can create criminal and civil liability for those who gain unauthorized access, and thus it can be argued that the restriction on posting the decryption software is not absolutely necessary to preventing unauthorized access to copyrighted materials. And I think that's a strong argument, and that's something that Peter and I discuss at length here. The court also adds, but a content-neutral regulation need not employ the least restrictive means of accomplishing the governmental objective. It need only avoid burdening substantially more speech than is necessary to further the government's legitimate interest. So they're not applying that full strict scrutiny test here because they don't feel it's necessary in this case. I think the fundamental choice that the court recognizes here and that we're discussing is between impairing some communication and tolerating decryption, or in other cases, tolerating some form of activity that someone might not like or might be illegal. Now, let's go back to Peter for more on his paper and what came after Corley.
And then what we do in the papers, we say, well, what happens after Corley, and has the Supreme Court ever rubber stamped it? And the end of the analysis, and we can get into more depth, is no, they haven't. And if anything, the Supreme Court's gone in the other direction. Supreme Court has come out recently and said, well, not too recently now, I think it's like 7 years ago, even pharmaceutical data brokers trading, records of what medicines doctors are prescribing, that information is worthy of full First Amendment protections, very bland, very non-expressive purpose. It's all about just dry information and very profitable marketing. Not exactly like a controversial novel, more just like a giant, drug company making more profits. And the other thing the Supreme Court has said recently is we're going to take more of an originalist view of the First Amendment, which would say that the lower courts, the courts of appeals, aren't allowed to start carving things out of the First Amendment or subjecting them to lesser protections based on the exigent circumstances of a given time. Like, oh, well, because software is eating the world, software no longer gets protection. That's not a permissible move, according to the Supreme Court. The Supreme Court says, look, there's like 5 or 6 distinct categories of things that historically didn't get protection, famously obscenity, like pornographic material, and defamatory statements. But outside of those established categories, we're not going to allow the courts to invent new categories of lesser protected speech. That case is Stevens, and it's very important, and it directly augurs against the move that the Second Circuit was making in Corley, where they said, well, some things are just going to be too bland and utilitarian to be worthy of First Amendment protection, most notably certain types of software. So this is an unresolved tension in the circuit courts. Some circuits have said we like Corley. Some circuits have said we don't. Supreme Court has never sided with the Corley side. The Supreme Court has sort of signaled it's going in the other direction. I think we are set up ultimately for a very important Supreme Court decision within the next 5 or 10 years where they're going to decide, is software pure speech and therefore always subject to strict scrutiny, or is it something that can be subject to lesser protections?
Now, as Peter just mentioned, this is an unresolved tension in the circuit courts, which are the Federal Court of Appeals, one step below the Supreme Court. Tension in those courts is typically what leads to a Supreme Court review, as Sam Enzer, a partner at Cahill, is about to explain for why he thinks an AI case is more likely to end up in the Supreme Court than cryptocurrency-related litigation.
I think it is more likely that a litigation involving AI ends up in the Supreme Court than Tornado Cash, for example, because for something to go to the Supreme Court in the U.S., it has to be an issue of national significance. So in other words, the Supreme Court does not have to take any case. They take cases on a discretionary basis when they think it's important for them to weigh in. Number 2, they almost never take a case unless there's a conflict, a split, a divide among judges. So basically, to get to the point where a litigation or an issue would get to the Supreme Court, you need a bunch of litigations in a bunch of circuits, and then you need a conflict to develop among them. And, the Tornado Cash case is one, we're talking Roman Storm, that's one criminal case, one narrow issue. Supreme Court almost never takes. I mean, Roman will appeal if he loses, but will there be an issue for the Supreme Court to take cert on? Will there be an issue that there's been a divide among circuits? Less likely than when we talk about the whole industry of AI and all of the many facets of technology and all of the disputes that are going to come up. That's a much better petri dish for test cases to come forth that could percolate up to the Supreme Court.
Will we finally get a Supreme Court ruling on code of speech? If so, what will be the defining lawsuit? I spoke about this with Preston Byrne, the managing partner of Byrne and Storm, who spent nearly a decade advising U.S. social media companies on domestic and cross-border legal issues, often with First Amendment consideration. Here's Preston on why he doesn't think a company like Anthropic or another large LLM provider will be the case to go to the Supreme Court.
I don't think Anthropic is going to be the case which decides how those models are treated from a First Amendment perspective. I think what will wind up happening is in 18 months, there will be an open source model, which is of similar capabilities to Fable or Mythos. And then what will happen is the government will try to restrict that. And that, I think, is where things start to get dangerous, because there you have something which is a pure expressive act, an act of publication, and the government is going to try to suppress it. And I think that's going to be an interesting question from a free speech point of view, where it's not just something which lives in a silo and is being offered as a product for a fee, but rather it's information which is capable, which is an expressive act, right? Coding something and then releasing it to the world for the purpose of the world receiving and understanding it. So I saw the export controls. I didn't think that was going to litigation, because Anthropic's incentives there were to make sure that was resolved as swiftly and cleanly as possible. And that's exactly what happened. So if it's a negotiated resolution, there's no case. However, there's going to be some open source dev who wants to publish something, and the government's going to say, we don't want it published. And there, you're going to have a fight on your hands.
Now, let's go back to my conversation with Peter. We were talking about the Corley case. Remember, that's the case where software was created that allowed users to remove the rights management encryption from DVDs and CDs, and then copy and duplicate those DVDs and CDs unencrypted. So the action of actually implementing the software is illegal, breaking copyright law. Should the action of creating and publishing the software that allows people to take that action be illegal? Here's Peter on the Corley case and the foundational cases on code as speech.
If you read Corley carefully, the Second Circuit opinion is actually very narrow because they knew you said it was 2001, right? I think that's right. Yeah. They knew we're wading into something really big. This was the very beginning of the internet in retrospect. Like to me, it was the middle of the internet.
That was
like
before software was eating the world, though.
But yeah, it was the .com boom.
Yeah.
There was this realization that people are going to be doing a lot of commerce online. Yeah. File sharing was huge. It was kind of the beginning of the end of the business model that the record companies used to have before they switched to streaming. This idea that everyone would just share MP3s everywhere. It was hugely important. And the court in Corley says, look, rather than craft a clear standard here, we are limiting our holding to this area of copyright law and its interaction with the First Amendment and software. And there's even some indicia in there that they basically, I think, hint at one point, we know we might get it wrong. It's really early right now. And so there was humility. I'm being very, in the earlier response, I was being a little aggressive in criticizing the court for Corley, but they were self-aware. They were like, we're about to craft rules for a technology we don't yet understand fully, and that will obviously grow and change massively in the next 10, 15 years. And so what's disappointing to me is not necessarily the Corley decision, because God knows I'm probably very wrong about a lot of far out ideas about technology that I have right now. It's that the mistakes of the Corley decision are still being repeated in the lower courts, even as the Supreme Court is not at all going down that road. And so the most obvious case of this is, well, there's two actually that are worth noting. One is the defense distributed case, which is the Third Circuit, New Jersey case about 3D printed guns. And so, again, you said it, Jacob, bad facts make bad law.
That was the note I had right there about the distributed defense distributed case.
God, yeah.
The bad facts.
As a quick sidebar, part of the hard work, and I don't mean oh, look at me, I do hard work. I just mean my work is actually hard. This is the hardest part because I don't ever know if I'm doing this right, is going into an office and saying look, I want to stand up for someone's right to pay for an abortion or a handgun. Because that's at the end of the day, what I believe in is that the payment systems should be free and open. And we should police people who do crimes after they do the crime, not sort of a pre-crime, you can't even pay for the thing that you're about to do.
Minority Reports.
Yeah. I don't want private companies and banks to be effectively the police and block people from making financial transactions that will lead to crime.
Yeah.
I want criminals to be arrested for doing crimes. This very different way of doing policing. And yes, mine's more expensive and it necessarily might allow for a little bit more crime because you'll have to catch it after it happens rather than before. But it also means you have far less false positives where you accidentally arrest somebody who is doing nothing wrong, or you debank them, or you forbid them from transacting. And how do you explain this to members of Congress, to their staffs, in a way that feels visceral and they understand, especially that this is mostly a hypothetical concern, because in America we mostly still have pretty free ability to pay, and the way to do it is to get into really ugly facts, which is you have strong feelings about gun control, you have strong feelings about the right to choose in a pregnancy. Let's have those debates about those things. Let's not try and foreclose the whole policy issue by controlling the payment systems that people would use to interact with those particular goods and services. But then it gets touchy because you're like, now I just walked into an office in Congress and I started talking about abortion and guns when I'm just supposed to be here talking about cryptocurrency. It's like your day got even worse, And so, yeah. And
they're like, wasn't he the coin center guy?
But now I'm just getting angry about other things. So, take that with a grain of salt as to like how effective we are. I think we're effective. But bad facts make bad law. Bad facts might make for bad lobbying. Defense Distributed is this case. A guy named Cody Wilson. He was actually he was in law school the same time I was in law school, I think, and I think he dropped out of law school and he started this company to share CAD files for guns, so that you could 3D print. I think there was a single shot pistol called the Liberator, which is actually I found this out the other day. The name is based on the single shot pistol that we airdropped over France during World War II. To try to encourage the French resistance to kill a Nazi.
That's good lord.
It'll only work once, but it'll work, And so Cody and Defense Distributed developed this CAD file that you could print using just the PFT plastic or whatever it's called, a single shot pistol. All you need is a bullet, and now you can fire one shot. And New Jersey, didn't like this. They have strict gun control laws, and I think they said, look, you're going to have to geo-block your website that shares these files for New Jersey residents. At one point, Defense Distributed was even offering to mail people a thumb drive with the files in Jersey, which is an interesting, sort of like a step towards, we'll publish the CAD file as a book, and now you're going to buy a book in New Jersey. Like, at what point is it very clearly speech?
Yeah.
But the court in Defense Distributed said they created the fullest to date judicial doctrine of lesser protection for functional speech.
And this was the Third Circuit.
This is the Third Circuit. Okay. And what they said is they actually there's no final resolution of that case yet. The recent holding that came out was the Third Circuit sent it back to the district court and said, we don't have enough fact finding on the nature of the software and data that is the subject of this case. We need to know more about how expressive it is, how instantaneously it can be turned into a gun. A file can become conduct. Right. Speech can become regulable conduct. And they said, we're going to have a multi-factor analysis. And some of the things in there are like, is it source code? Is it machine code? Is it expressive? Or is it just like ones and zeros that a machine will use to print a gun? And so I get it. They're trying to say we want to protect people's rights to share ideas like blueprints and schematics for innovation, even in the context of weapons. But we don't want to, instantly enable a person in New Jersey to print a handgun. That's their concern. And I'm sympathetic to that. This is bad facts make bad law. I'm not a gun person myself, even though I'm a Bitcoin guy. A lot of Bitcoiners are gun people. I'm sympathetic to the factual difficulties here, but I'm not at all on board with the holding they came out with, which is this extremely context-intensive analysis for whether something's going to get First Amendment protection or not. Because is it beautiful enough? Is it artistic enough? Or is it simply dangerous, bland, commodity-like facts about the world? Because I don't think you don't want to put judges in that position of deciding what's worthy of being shared.
Yeah.
What's worthy of the name speech and therefore the protections.
Yeah, that's actually, that brings me to my next question. I love doing a good segue for a podcast, Peter. Really, and I think what you guys have here is the primary challenge for courts is determining where software publication ends and regulable professional conduct begins.
Yeah.
And that's such an interesting dynamic. Like, even when you were talking there, what came to mind to me was the idea that, like, at what point is it speech? Is it expression? And at what point does it become like an instruction manual for doing something bad? And that's like such a thorny question. Or is it?
Well, I was just going to say, like, and this is why it's so difficult, even an instruction manual for doing something bad is still speech.
Right.
Where it gets really hard is, when are you actually doing something bad?
That's
right?
what it should be. And
Right?
I think that's the fundamental thing that we've sort of been, this whole podcast is about, is like, we're not talking about, and we don't want to live in a Minority Report world where people are getting arrested for crimes they haven't done, but some algorithm thought they might. And I think in the day of an age of AI, that type of reality gets dangerous.
It's very real. It's on the horizon. Yeah.
Exactly.
Yeah.
And so what we're saying is like, just because someone downloaded an instruction manual to do something bad, does not mean that person is worthy of punishment, does not mean that person was going to do that thing.
And especially if the instruction manual is for things that could be bad or could be good. And almost all of crypto is that, almost all of crypto is, here's a way to make a binding agreement with someone across the world to maybe move something of serious economic value, like $1 million. Now, if that's me, being paid because I'm a content creator, and my content is good.
It's true.
Then that's unambiguously good. Like, what if this is like the neutral news source that everybody wants in this world where news has become politicized, and you say, instead of taking advertising revenue from big corporations or nefarious entities who might want to push the editorial bias one direction or the other, we'll just do direct to consumer and we'll do payments like that. That's the good use of this, right?
Maybe we should do that. That's a good idea.
But the technology is neutral. The same person can say, I'm going to, build a factory to enrich uranium, and you can pay me to, get the resources I need to build that factory to enrich uranium.
We won't do that.
Don't do that. But we can't then look at the payments technology and say, it's facilitating uranium enrichment, therefore it's not speech and it's not protected software. Because then we're effectively outlawing technology that mostly has good uses, has some bad uses.
And it's the activity, right? Like, that's the crux of your paper. It's like separating the activity from, I shouldn't say that's the crux of your paper, but that's an underlying theme prevalent throughout the paper.
I love the term crux because I've gotten into bouldering lately.
Is that a bouldering thing?
I think crux might come from rock climbing originally.
Oh, okay.
It's like, or maybe it's just a commonly used term. It's like you've had this hard, climb up, and now there's this one moment where the next handhold is way over here, and you're halfway upside down, and you've got to get it. And if you get over the crux, you're going to get to the top of the mountain. And the paper does have this quality in that we go through this. I think straightforward analysis of why the lower courts are wrong on this functional theory of code, and how the Supreme Court has said that there is no such thing, and that the only lesser protected speech are the discrete categories of obscenity and defamation, fighting words and things like that. And then after that segment, which is still controversial because there's plenty of First Amendment scholars who think the Second Circuit's right in Corley and the Third Circuit's right in Defense Distributed, and the Supreme Court, they've said some things that sound against that, but they haven't ruled. So that's an important debate. Yeah. The next part of the paper is what you were saying about this delineation between speech and professional conduct. And that is a area of First Amendment jurisprudence that is actually huge, even more underdeveloped, perhaps, than the general software context. And it's cryptocurrency software that is going to push that over the edge into a fully developed area of First Amendment law. I hope it goes the way I want it to go, but to listeners who are more neutral and just interested in First Amendment jurisprudence and this area of the law, this is something to watch, whether you agree with my opinion or not, because there are a handful of cases here. And so what we're talking about here is less whether the speech is worthy of protection. In fact, the Supreme Court has recently said that the speech of a professional, so you're a lawyer, I'm a lawyer, we are professionals, we can be licensed, right? We're not allowed to practice law without a license. How is that not, given that law is mostly just what we're doing right now, speaking, how is that not a prior restraint on speech? And the Supreme Court has said in those old licensing cases, no, you're regulating the professional conduct of the lawyer, i.e. the fact that when they take on a client, they're representing to the client, they're going to act in their interests, they have professional responsibilities, they're legally binding things that are going to happen because this agent of the principal, this lawyer for the client is going to file a document that's not just speech, it's a legally binding document. You've now bound the hands of the principal by settling a lawsuit or something like that. We can say you're only allowed to do that conduct of binding your client, respecting your client, honoring your duties if you have a license. What we can't do is stop someone who isn't representing clients from just talking about what the law should be, or even giving advice to some extent about what the law is, as long as it's general advice, not aimed at a specific client to whom they owe a duty. That is fairly clear in the context of law licensing and things like that. There was for a while a strain of cases that said that when you are a licensed professional, the speech that you give is subject to lesser protections. This notion that like a doctor can be told to limit his advice in a certain way, or to give specific advice that maybe the doctor otherwise wouldn't want to give. That area of law has also been recently resolved. The Supreme Court has said in a series of cases about, again, very contentious subject matter, conversion therapy for psychiatric professionals or psychological professionals, whether they're allowed to like say, if you don't want to be gay, you don't have to be gay. Let's talk about how you're not gay. Conversion therapy, if you want to be a practicing therapist and do that, the Supreme Court says you can. That your professional speech, even as a licensed therapist, can't be compelled to only have a certain view. Like you can't tell your patient that they can pray away the gay. Very contentious stuff. And this is, how do I feel about these cases? I feel like, was it Voltaire? I may disagree with what you have to say, but I'll defend to the death your right to say it. That's pretty firmly how I feel there. And in the abortion context, so the other case on this line of cases is about clinics, family planning clinics that are not sharing with the expecting mother literature on where they can get an abortion. They're just sharing literature about adoption and like bringing your pregnancy to term. The Supreme Court in those cases said the professional speech, there's this question like, is it worthy of full protection, or can we tell the professional they have to say certain things like an abortion is available to you? Supreme Court actually said, no, the professional speech is still fully protected. So the California law or whatever that says you have to recommend potential abortion clinics is a violation of the First Amendment rights of the doctor. Contentious stuff. Yeah. So anyway,
we're hitting all the notes.
That's all a little bit to the side. That's now pretty clearly Supreme Court precedent. That professional speech doesn't get lesser protection. The hard question in cryptocurrency is, where is the line between your speech as a professional and your conduct as a professional? So to go back to the lawyer example, when are you just giving a general speech about the law versus a specific speech to a client about how the law might impact them?
One thing I quickly want to say on that, because I think you guys do a great job actually mentioning this at the very start of the paper, that whole point that you just made, which is the ancient common law of agency, where, yes, there's this...
You would like that, Jacob.
And you're free to say that. There's these legal duties that arise when someone's working on your behalf, when you're working for someone else, when you're doing something for someone specifically, and that's narrowly sort of scoped. That, to me, like when you just said that, it's like, oh, yes, of course. When you're building, like if you set out to build some sort of tool for some money transmission for some North Korean person, build that tool for them, and it's very clear that that's why you're doing that and everything. You're communicating with them. To me, that's maybe where we need to get to, because that is, yes, there's still speech there, but that is also activity that's coupled with it. Whereas if you're building something and then the North Koreans end up using it, that's very, very different.
I think that's right. Like Coin Center's not interested in saying that the person who, answers the phone call from the cartel money broker, and the cartel money broker is saying like, I'd really like to know how to get this Bitcoin clean. And they're like, well, you can do A, B, and C using this tool that I've built. At that point, we're not talking about someone's speech rights. We're talking about someone aiding and abetting a drug trafficker. The problem is, when do you know that you're engaged in that conduct versus when do you know that the person you're trying to prosecute is actually not engaged in conduct? They just built a tool of general use, in which case they retain their First Amendment, right to publish the details of that tool, to host a website that keeps that tool available to the public, just like the New York Times hosts a website to keep their news content available to the public. That line is indistinct in the literature. And so the second half of our paper delves into the relevant case law there, which some of it comes from this professional licensing context, like lawyers. The most interesting case to me, and really the only one that's totally on point with respect to crypto and financial regulation, is Lowe versus SEC. And so to give a little background on that case, because I think it's very interesting, Lowe was, by all accounts, and I don't mean to be slanderous here, but a pretty shady dude, right? He used to have a bunch of clients as an investment advisor, and he was a registered investment advisor with the SEC and probably some state securities regulators. And he would tell his clients, you really just need to buy these 10 stocks. And why is he recommending these 10 stocks? Because behind the scenes, he's taking money from the issuers of these 10 stocks to pump them, right? Direct conflict of interest. You're supposed to be, you have a duty to the people who you're advising as investors, but you're actually being paid by the people whose crap they're going to buy, and you're going to feed it to them. So probably rightly lost his registration, and the SEC barred him from investment advice. Lowe, being quite evidently very enterprising
Content creator.
It reminds me of a lot of like crappy people in crypto. Like, the world doesn't change. It's always the same with new technologies. He starts a 25-cent newsletter that you can buy on the streets of New York. It's like in one of those boxes that has the little coin thing, and then you pull it out. And lo and behold, what's in the newsletter that Lowe is publishing? The same 10 stocks.
Classic
and how
Lowe.
You can buy now and get in early. And he's still being paid by the issuers of these stocks to feature them in his publication. And so the SEC, and I totally understand why they would want to do this, says, we revoked your freaking investment advisor license. You're not allowed to keep publishing this stuff. And he said, aha, it's just a newsletter. I don't have any clients. I'm not an investment advisor. I'm publishing a newsletter. And so this case goes up to the Supreme Court. The Supreme Court, interestingly, and this is why we don't actually have totally definitive law here, the majority opinion of the Supreme Court says we're going to interpret the securities laws and the investment advisor laws as not banning the publication of a general newsletter, even if it's paid, even if it's like 25 cents. Because we think if we did interpret the Investment Advisor Act to limit that, it would probably be unconstitutional. So they use what is called the constitutional avoidance canon of statutory construction. That's the majority holding. So technically the majority holding isn't a holding on what the Constitution and the First Amendment says about professional regulation. It's a holding about what the securities laws say, interpreted in a way that avoids constitutional issues. But there is a concurrence. The concurrence from Justice White does get into the constitutional issue. It says, my majority companions want to simply read the securities laws as not actually in this dangerous territory, but I think we're going to need to actually articulate exactly what the dangerous territory is. So he's agreeing with the outcome, but saying this is actually a constitutional matter. And so you could argue that this is actually because he's the deciding vote, this is actually the Supreme Court precedent on this matter, but that's somewhat debatable. It says, look, professional conduct as distinct from speech, and which means it can be subject to regulation. In fact, it might even get rational basis review, not even intermediate scrutiny, and certainly not strict scrutiny. So it's almost certainly going to be a constitutional regulation if it's just the conduct. What does that look like in the financial information context, i.e. a newsletter for stock tips? And what he says is, if you take the affairs of a client in hand and purport to act in their interests as you understand them in the way you now speak, that is professional conduct. And so there's a couple things in there. I think it's the right test.
Yeah.
It's not general speech. And so most free and open source software is not published for a specific person to use for a specific thing, right?
Mm.
It's published, anybody who has this particular need can use this software and the computer will run and do this thing.
Right.
And the developer doesn't have the particular needs of an actual client in mind when they do these things.
Mm-hmm.
Now, there's a limiting principle here, even in the cryptocurrency context. So to back it up real briefly, that's the standard for when the securities laws for investment advisors would apply.
Right.
I think it should also be the standard for professional regulation of software development when you're actually doing professional conduct as a software developer, not just publishing software. But that we've sort of yet to see that. But what would that look like in the cryptocurrency space? And our paper goes into this in depth. It says, look, you're publishing the Bitcoin protocol as a core developer. Obviously, there's no taking the affairs of a particular client in hand and acting in their interest. You've built a protocol that's going to be used by thousands, tens of thousands, hundreds of thousands, millions of people to do things that you're not doing. They're going to do it for whatever they want to do. Now we can go down the road, though, and get to more specific types of software. And I would say even something like the immutable smart contracts and Tornado Cash. Coin Center used those for our purposes, which was fundraising. Our donors wanted privacy when they donated in Ethereum to Coin Center. And yes, it seems as though the Lazarus Group of North Korea also used those for their particular purposes, which was unfortunately laundering the proceeds of a hack. And the developers of the Tornado Cash protocol, they were not taking the affairs of Coin Center in mind when they developed this privacy tool. They might have thought about it. They might have been like, oh, there'll be some good nonprofits that might use this. They also weren't taking the affairs of the Lazarus Group in mind when they developed the Tornado Cash protocol or maintained the website where it was available. And so to me, that is still not professional conduct. You don't have an agency relationship or a duty or any kind of privity with a person's particular need for your software. You're building a tool of general usage. Now, where does this start to fall off? Because I'm not a crazy radical. I don't think because software.
Well, I'm just kidding.
No, it's fair. But I don't think because software is eating the world, we're never going to be able to regulate anything anymore.
Now, I just want to pause for a second because where speech ends and conduct begins is a dynamic I spoke at length about in the context of AI with several other guests, including Professor Jane Bambauer, who was the chair of the National AI Advisory Committee subcommittee on law enforcement. Here's Jane on how the Supreme Court might approach the distinction.
I think it's inevitable that the Supreme Court will have to decide something about some aspect of, which parts of AI services do count as protected speech and which parts don't. But to show why I don't think there's going to be one comprehensive case, I think the Supreme Court would have to treat two different forms of AI code differently. AI chatbot output looks like speech, it's used like speech, it's interpreted by listeners as speech. That, I think, has the strongest, or at least among the strongest cases to be protected, even stronger, arguably, than the cryptography cases from the 80s and 90s. On the other hand, if you think about AI code where it's designed and transferred to a consumer for the purpose of like pressing a button and immediately initiating the code, and the code has immediately physical ramifications. So for example, a self-driving car's software implemented and embodied in a car, I think you could call it pure code, but I think the Supreme Court would probably, or the courts in general, would probably feel comfortable saying, well, we're actually going to treat that as a product or conduct or something that falls on the other side of the line because it's actually not even intended as a message. It's intended to be run, right? But that, I mean, even as I'm explaining that, you can see where the tension is. It's like, really, we're gonna do everything based on the intention, whether code is meant to inform by looking at the code and understanding the code versus code is meant to be run mindlessly without even thinking about it. That distinction almost doesn't make a difference.
Jane raises a really important point. There's this tension between code that enables activity and the activity itself. For example, in the case of AI, what if the inputs and outputs are speech, but the design and transfer of AI is not speech? wouldn't the regulation of the design and transfer implicate speech? Preston Byrne helps distinguish the differences here.
I mean, I think the act of coding, right, and developing and publishing an open source model is itself speech, right? Forget what the downstream consequences are. There are some things you can do with an AI model that are not expressive, right? So it's not expressive for me to use my AI model in my car in order to give it self-driving capability, right? That use is not expressive. But if I'm doing something like writing an article or something like that, and I'm using the LLM to produce ideas, and those ideas are derived from my own because they've been prompted by me, right? And that's all part of the context window that I've created. I can't see a compelling argument because ultimately the stuff that you've generated, just like writing down words on a page, you can imagine free writing as being something similar. You're putting something out there and you're getting something back. Through a system that, you could be rolling a bunch of dice. It comes out with a number. You choose to write it down. So it'll be really interesting to see how the courts handle it. I think you'll have to have the right lawyer argue the case, and they'll have to explain it very clearly to the judges exactly how the thing works. But certainly there's a whole realm of expressive conduct, which is benign, or even if not benign, it's something that people should be permitted to explore, where this stuff is going to be challenged. I can see Europe, for example, cracking down on this hard because they don't have any similar doctrines. They ban books, that kind of thing. The US is going to have a big problem because you're going to have this technology which is capable of being used for some very dangerous things, but also capable of being used for some very wonderful things. And we don't permit prior restraints, right? What we do is we come in after the fact. If you use the illegal tool for the illegal purpose, then, right, you have the law gets involved and you start to have judicial or legal intervention. So it'll be interesting to see what happens. I haven't fully thought through exactly how it's going to look, but it'll depend on the nature of the infringement that gets handed down by the states. It'll probably be the states that do it first rather than the federal governments that do it first, just because the states tend to be more nimble and move more quickly in tech regulatory stuff.
Those comments bring me back to the point Peter mentions, which is punishing the criminal activity rather than the code's publication. Here's my question to him. One thing I want to quickly just say on that point too, because it applies in the securities context and that example that you gave in the Lowe case, which is if you're writing a newsletter and you're getting paid by securities issuers and you're promoting those securities issues, there can be rules around disclosure.
Yes.
Where you disclose those relationships. And when I lived in Germany, I worked for a startup and we did influencer marketing. And this was before there were any rules about what you had to disclose. So you could say, hey, I love Sharpie. Sharpie's the best. I use Sharpie in everything. You should go buy a Sharpie. And there would be no little ad or partner or no disclosure. And guess what? Rules were created. So now you can still have that free speech. Only now, like you said, there's some more conduct to it. There's something behind it that almost compels your speech. You're acting as an agent in a way.
But you also, you hit at another area of the professional conduct regulation jurisprudence that we do get into in the paper, which is strictly non-controversial factual disclosures. So in, say, those cases about medical professionals, they can be obligated under statute to disclose the factual risks of a procedure because we know that the consumer of these medical services deserves to hear them. What they can't be forced to do is speak things that are not non-controversial and not strictly factual.
Right.
So, and we get into this in the paper as well. If we look at the cryptocurrency context, let's look at the IRS's broker rule, which Congress invalidated using the Congressional Review Act. But had it not been invalidated by Congress, would have required a lot of software developers of DEXs, decentralized exchanges, to collect information on the people who are trading on their using their software on chain, and what their capital gains is, what their basis is, and basically file a 1099, just like a typical broker-dealer would, to the IRS as a way of, carefully, it's the stick to the carrot of you should probably tell the IRS what your capital gains are, because if you don't, the broker's going to call them up and tell them, and then we'll have a discrepancy, right? And so the interesting thing here is if the DEX software developer actually already had this information, like they were a typically engaged broker who has customers that they onboard regularly, that they deal with regularly, that they know the name and social security number and all the other things too, and they know their trading positions because they have a duty to them, they have an agency-like relationship with them, then it would be a strictly factual disclosure to have them compelled to send to the customer a form with their capital gains. And probably, though there might be Fourth Amendment questions, but probably it would be fine to have them send the same form to the IRS because it's strictly factual. And you're forcing them to speak because even a dry disclosure is speech. But because you're only forcing them to say non-controversial factual things like you traded X at price Y, and that means you had a gain of Z, that is constitutional. The problem with the broker rule is most of these software developers to whom an aspect of the now canceled broker rule would have applied have no customer relationships. They publish a smart contract to the Ethereum blockchain, and people use that smart contract. And that is an immutable smart contract in many contexts. And they have no further relationship with the people using this infrastructure any more than the guy that paves the asphalt on your road has a relationship with you because you drive your car out of your driveway in the day. And it would
just to clarify, for people who don't know, immutable means they can't change it. They can't upgrade the code. They don't have admin keys. There's nothing they can do.
It'd be even more difficult than the guy that paves the asphalt on your road to come out and change the asphalt. They literally can't, and they have no relationship with you who are using this infrastructure, right? At that point, forcing them to collect information on the people who use their infrastructure and report it is not just a compulsion to disclose already known facts. It's a compulsion to engage in an entirely different activity, which is being a typical broker-dealer with customer relationships, because you'll have to establish those relationships to collect those facts. And that means you're going to force them to write a bunch of software that actually does fundamentally different things than the software they were writing before, on an ideological level, fundamentally different as well. Because people who, in good faith, want to build tools like DEXs, they are doing this because they don't believe that there should be an intermediary essential to every peer-to-peer exchange of one asset for another. They think that's something people should just be able to do using immutable software that's free and open without some potentially exploitative company in the middle. And so when you're telling them you have to be that company, you have to collect that information on the people using your infrastructure, you're basically telling them that their idea about how the financial system should be built is wrong, and they should actually be compelled to build a financial system that's more like the old version that had this inherent middleman in it, this necessity for a middleman. And so at that point, it's not the disclosure of non-controversial facts, like a warning on a tobacco label. It's actually compelled speech of highly expressive qualities, which is write the software that is our idea of a good financial system. Stop writing software that is your idea of a good financial system. And the case law here is also fascinating. I'm not sure if we go into this case in the paper, but one that comes to mind is actually the tobacco label context. So there's
I didn't see it, no.
No, it's not in the paper, but I'll talk about it anyway.
Yeah.
There's a famous case where if you've ever traveled abroad, and you were talking about being in Germany, you've noticed that the cigarette labels over there sometimes have disgusting, terrifying pictures
in Canada,
decayed gums. Oh, that's right. You're from Toronto. Yeah. Decayed gums or black lungs or people with the buzzer up on the. It's this will happen to you, right? American regulators wanted the same labels on American cigarette cartons. And it might have been Brown & Williamson, one of the big tobacco companies, challenged it and said, you're allowed to say that the Surgeon General has found scientifically that our product causes cancer. That is a non-controversial fact that we can be forced to disclose on our product labeling. You can't force us to write a horror story or draw a horrible picture.
Interesting.
'Cause that's not a fact. Some people are going to smoke and they're going to get sick and they're going to look like that, but many people won't. You're obviously evoking an emotional response here. This is not just neutral facts.
Yeah.
And so that is actually in the US unconstitutional to force a label that is horrifying onto a product. You can force the company to disclose facts about their product, and I think that's right. You can't force them to effectively cut the legs out from under them by putting a giant skull and crossbones on the thing or disgusting images of decayed gums. And so to me, this is the most interesting area of law because these are really difficult questions. And in cryptocurrency, this is exactly where we are. Like if you have somebody who's running a decentralized in name only cryptocurrency, and they really could easily learn anything about all their users because they're right in the middle of all of their users' transactions, then they should probably be obligated to be regulated and collect information, disclose information, just like a typical broker dealer or money transmitter. But if you actually are just a person who's built an amazing and elegant software protocol that allows people to transact on their own, and you could get hit by a bus and they'd still be able to transact on their own, first of all, I think you've done something beautiful. You've built a resilient system that allows human flourishing and peer-to-peer bottom-up interaction. But also, you can't be forced to change your software to put yourself back in the middle of the transaction because the government really wants to learn more about the people transacting. Like that is fundamentally un-American, I think, and also unconstitutional. See our paper.
Now, Peter mentioned his paper, the Coin Center paper on software is speech. One of the themes of that paper goes back to the situation Bernstein faced in the 90s. As we already discussed, cryptography at the time was on the United States munitions list. So Bernstein went to the State Department, asked whether he needed a license before publishing. They said yes, but he asked if he could get one. They said no, explaining they would deny it if he applied because his encryption was too strong. What happened then and what's happening now to certain crypto developers isn't too different. Some are actually being charged for money transmission after others used the code that they published. And to be fair, in some cases, they didn't just publish, they also hosted platforms, upgraded the code, and did some other things that allowed people to send cryptocurrency. FinCEN, which stands for the Financial Crimes Enforcement Network, part of the U.S. Treasury Department and responsible for administering the Bank Secrecy Act, which is the relevant law for money transmission, put out guidance in 2019 that an anonymizing software provider is not a money transmitter. Prosecutors who brought these cases against the software developers had even asked their colleagues at FinCEN before the indictments whether one of the non-custodial wallets and software they went after constituted money transmission. And FinCEN actually said no, which to me suggests it would have been impossible for those developers to even register as money transmitters, yet they were later charged for unlicensed money transmission. Kind of similar, analogous to Bernstein, right? Back to my conversation with Peter, who touches on that dynamic.
FinCEN and the states have said that software development is not money transmission, so they don't need to get a license from us. In which case, if you're prosecuting somebody for unlicensed money transmission, but the regulator said you didn't need a license, you're just screwed. Like, how am I even supposed to publish this software if the regulator who you're saying I need to get a license from says I don't need a license?
See, I told you it was very similar. And Peter isn't saying that the rules shouldn't apply anywhere, as he clarifies here.
That doesn't mean that everybody who builds crypto software is a broker-dealer, a money transmitter. It means that a lot of them are simply outside of the realm of prudential regulation or financial regulation or anti-money laundering regulation, not because we're anarchists, but because we're patriots and we believe in the First Amendment and your right to publish software that others will use to do what they want to do.
Now, as Peter notes there and has been noted throughout this episode, the First Amendment isn't absolute. As Professor Eugene Volokh explains here, it also doesn't protect our right to send money to people.
The First Amendment, again, is really important. It protects our right to speak. But it doesn't protect our right to pay money to people. I mean, sometimes it does, like it protects our right to pay money for speech. Like if somebody were to say, well, you can write a book, but you can't sell the book. Well, that would be a First Amendment violation. There have actually been cases that are kind of related to that. But it doesn't generally protect a right to transfer money. The right to transfer money in various ways has been regulated in various ways. It's been taxed in various ways. It's been subject to anti-money laundering restrictions, all sorts of things. And you can agree or disagree with a lot of these restrictions, probably a lot of economic restrictions I would personally disagree with. But those are for the political process to decide on, and not for judges to say, well, paying money is really communicating from computer to computer and changing bits of data, which is information, which is speech in people's bank accounts. Therefore, there's a First Amendment problem. That can't be right. The First Amendment can't be the amendment that eats all of regulation.
And that makes sense, right? The First Amendment, as Eugene said, can't be the amendment that eats all of regulation. They wouldn't have written the other ones if the First Amendment covered everything. So where do we draw the line between speech, between publishing open source code, and sending money to people using that software to conduct the activity. That's one of the last questions I asked Peter, because I wanted to know, like, where should we draw this line, right? Between if you're doing something that facilitates another activity, which could be published in software, or doing something that facilitates another activity, like providing internet to someone. If you start to go after developers of software, where does it end, right? What about the internet service providers who actually have additional rails that are needed to facilitate all these transactions? What about AWS? So there's so much.
Yeah.
It's a slippery slope and a dangerous path that you could go down.
And slippery slope arguments, some people think they're silly sometimes, and they're overused by alarmist civil liberties lawyers and things like that. But I think in the free speech context, it's extremely real.
Yeah.
Because once you know that somebody wrote down some symbols and ended up in jail for it, you're immediately going to think twice as to whether you're going to write something down yourself. And so the chilling effect of overzealous policing of the publication of ideas, whether they're software or novels or political treatises, really does rapidly devolve into the slippery slope. It's not really a slippery slope. Even if enforcement is only limited to the 3 bad actors who really shouldn't have published that book that gave people bomb-making instructions, immediately everybody who's writing speculative fiction about, like, bombs is going to be like, well, maybe I won't write that. And then immediately you're going to think, well, I have this inflammatory but nonviolent, thing I want to say about this current president, but I see that someone just got arrested for publishing something, so on. And then you lose this American ideal of the best remedy to bad speech is more speech. That's this notion of the marketplace of ideas. I think it's Brandeis. I may be wrong about that. And you go into this world where we think, well, we'll just police speech, which is just fundamentally anti-American. So I think the slippery slope argument is real here, because you need a black letter, clear principle for when you're going to be safe and unsafe. And if we start saying, like, well, because of the equities, because this is a really bad example, we're just going to have a flexible standard for this part, then the whole black letter standard collapses. And we get into that a lot in this paper. But you need that justiciable standard when what's on the line is people's comfort in expressing their deeply held beliefs.
Yeah, no, that's such a good point, Peter. And if there's one thing that you can use that sort of breaks that free speech protection, that makes the United States a unique country, a place where people want to come to, where builders flock to, that can be weaponized. Like you said, the chilling effect, and then sort of the counter side of the chilling of developers and builders is that weaponization of political opponents. Those are things that happen in other countries. And that's a reason why the forefathers of the United States created the Constitution, built this country, is to be different than that. And if we lose sight of that, I think we go down, I don't want to say a slippery slope because I promised I wouldn't, but it's a dark abyss.
Yeah. And we immediately stop being America. What makes me passionate and patriotic about America, right? Yeah. Which is this idea that you can express your mind. There's no thought crime. You can say what you want to say in the public square. Yeah.
There needs to be a standard. And the idea of a slippery slope is one that often comes up in discussions around the First Amendment in particular. It's also one that Eugene Volokh, again, the longtime law professor and First Amendment scholar, wrote an entire paper about titled Mechanisms of the Slippery Slope. He has a fun graphic in there that, if I am able to, I will put on the screen now for anyone watching. I asked him about that paper in this context, as I think it's important to be mindful when we make these slippery slope arguments, how we should be thinking about slippery slope concerns. Here's Eugene.
Slippery slope concerns are a way of thinking about indirect consequences. Not just what will this particular step do by itself, but also how will it change the environment, the legal environment, the economic environment, the psychological environment in which future steps take place. For example, people who are skeptical of surveillance say, well, if we allow a certain kind of surveillance by itself, it may not be that much of a problem. We'll get used to the surveillance, and now we'll be in an environment where the surveillance becomes the new normal, and future surveillance will therefore become even easier to implement. And maybe you would say that's fine, because more surveillance may be unbalanced good, may have costs, but it also has its benefits. But you need to be able to do this kind of thinking about the future. I think it's usually thought to be a sign of prudence, a sign of thoughtfulness, that you think about indirect effects of what you're doing and not just the immediate and the direct effects. At the same time, of course, future is very hard to predict, right? And it may be that we don't really know what the costs and benefits are going to be indirectly. And at some point, we might just say, let's maybe set up mechanisms that will help us make good decisions in the future, so that if we see something bad happening, we can stop it then. And of course, one thing to keep in mind is that these are just one kind of effect, slippery slope effect. Another kind, which is of course very important in the AI world, is competitive concerns. We know that the Chinese are, by Chinese I mean communist China, are working on this and are actually very good at AI. I'm sure the Russians would be looking at this. For the Iranians, they've got other things to worry about right now, but I'm sure they and others would be looking at this too. The practical effects, both for purposes of economic growth, and economic growth equals economic power, which translates into military power, and for immediate military applications, are tremendous. And we can't just sort of say, well, nope, too dangerous, we're just going to stop developing AI, because then our rivals will do that. Now, of course, that itself is a potentially dangerous system, dangerous kind of arms race, but I'm not sure it's an avoidable concern. I think this is something like we've got to keep developing AI, partly because also it has a lot of just important peaceful uses for helping cure disease and a variety of other things. But on top of that, it's also something where we can't unilaterally disarm ourselves.
Now, the difficulty here is finding that line between speech and activity. But maybe that is the line. Maybe that's where we draw the distinction between publishing and activity being taken. Well, that gets to the facts of each situation, which is key in the context of cryptography, cryptocurrency, and AI. One example where the Supreme Court seemed to wrestle with the application of code, in this case, the functional use of data, was the Sorrell case. Peter mentioned it before. I also asked his co-author, Laz Pieper. I might be butchering that. Sorry, Laz. I meant to ask you how to pronounce your last name when we were on the call. Here's Laz to talk a little bit more about the Sorrell decision. Again, this was the one where it was about the functional use of pharmaceutical data for marketing. I asked him also about how we should think about the functionality of some speech.
Just because these computer instructions, someone can take them and use them for something, that doesn't change their degree of protection, right? And the fact that they can execute these functions quickly, the Supreme Court has never decided that certain information has lost its protections just because one is functional or that it can be used effectively or efficiently. Mm-hmm. In fact, they say the opposite, right? If you look at Sorrell, specifically Resi MS Health, they were dealing with pharmaceuticals and prescriber identifying data, right? And Vermont had a law that said that this prescriber identifying data cannot be bought or sold for the use of pharmaceutical marketing. However, it could be used for research purposes, which was kind of an interesting take. And the court said, no, this data is information, and said, yes, this is still protected. It's information. And Vermont couldn't just ban it in one context and give another speaker the ability to use it for research, right? So the Supreme Court looked at functionality there and said, just because this data is dry and mostly has utility and not really, as we know, is expression, that doesn't change its protections, right? It's still information. And just because it's useful does not change whether or not it's speech under the First Amendment.
Now, it's important to note that another step had to be taken in the Sorrell case for that data to be used in marketing. It wasn't just a button that someone could press to do something illegal, like the sculpture example Professor Volokh gave earlier with the machine gun. I think the further you get from the activity, the more likely the constraint is to infringe on the First Amendment. And the closer you get to publishing, same is true there. Here's Laz again on that point.
So the government doesn't prosecute the person who publishes propaganda. That would absolutely violate the First Amendment. They go after the people who are actually trying to revolt and overthrow the government, right? That is illegal. There's a difference between publishing software and actually running it, and distinguishing who's actually committing the act, right? Is it the publisher? Is it the independent third party, right? And we should, in some cases, look at what this independent third party is doing with the software, or really any tool, right? That's been a big question in crypto, and I think an evolving question with AI. The third party liability, right, are you going to be held liable for how someone else uses what you've made publicly available to the world?
Now, that's a great question, Laz, and I don't have the answer, and no one really does until the Supreme Court issues a ruling. But I think it's clear that protecting speech is important, not just for software, not just for freedom, but democracy itself. And I spoke about this with Preston Byrne, the managing partner of Bernstein. Here's Preston.
I define democracy as the right of people to make up their own minds and then choose their leaders at a ballot box, right? And if you're cutting people off from information, what you're doing is you're essentially rigging the marketplace of ideas so that people reach the conclusions that you want them to reach. And in my view, that's not compatible with my definition of democracy.
Free speech is always under threat, not just in the US, but also elsewhere. Here's Preston to explain more on that, as he's been involved in helping American businesses deal with regulators in other countries trying to infringe on the speech rights of Americans.
Free speech, you're always kind of at a crossroads with free speech. It's always under threat. There's always some political force somewhere who wants to restrain it somewhat. And is willing to interfere with people's freedom to try to get control of new technologies or other things. So I don't think we're at a crossroads in America. I think Europe it's like in the rearview mirror. You know, they've had their moment. They're now well down the road to, not totalitarian. Perhaps that's a little extreme, but they don't have free speech there, right? They're not free countries with respect to the expression of ideas, the development of software, the hosting of internet platforms. And I think there are a lot of people in the United States who'd like to do the same thing here. So, fortunately in the United States, we have the technology to beat back those types of sensorial developments. But yeah, free speech is always under attack everywhere all the time. It's at a particularly low ebb at the moment in places like the United Kingdom, so low indeed that they feel that they have the right to come into the United States and try to tell us what to do. That's the kind of thing that really gets my nose twisted. So yeah, I think the fight is always there waiting to be had. And so I think the United States is not necessarily at the low ebb, but it's not great. We could be doing better.
And when he says we could be doing better, I know he's talking about the United States, but I think many people around the world feel the same way. I tried to do my part with this episode, but there's so many others who are doing so much more. There's a lot of work being done by Coin Center and Pieper and his co-author Laz, as well as the sponsors of this episode, including the Hyperliquid Policy Center, which recently filed a joint comment in response to the CFTC's request for information around rules fit for purpose to financial technology as it evolves. And they recommended that we tailor the rules so developers can build and registrants can modernize. I think it's really, really important work that they're doing at the Hyperliquid Policy Center, and I'm glad to have them as a sponsor. Same is true for other guests in this episode, Jane, Eugene, Sam, and Preston. Don't worry, we're not done yet, who all do important work in educating and upholding the First Amendment. Preston is actually working on a state-level bill in Wyoming aiming at protecting Americans from foreign digital censorship. I'll let Preston explain the Granite Act.
Yeah, the Granite Act's pretty simple. Basically, it's a shield law, which is designed to address the censorship modalities that we have seen from foreign censors trying to get into the United States, as I've observed it over the last 10 years. And generally speaking, what happens is this. The foreign censors don't seek to domesticate the orders in the United States, but what they will do is they'll target service providers who are outside of the U.S. They will threaten you with arrest. They'll threaten you with fines. It's principally based on the making of threats. And the objective of those threats is to outsource censorship from the European government to the American tech company. So the American tech company carries out the censorship that the European government doesn't want to sully its hands with. And what they do is they say, listen, we want you to do it for us. We're going to define the stuff that we in our country doesn't want to see in very vague terms, in terms of very vague duties and all the rest of it. And we want you to take a lot of that down. And if you don't take down enough, we're going to fine you. So it's about exporting the political and technical costs of the political censorship they want to carry out, while also ensuring that they don't have their fingerprints on it when it's done. And people will complain to X or Google or Meta or others and say, this is a bad implementation of your policy. So that's what it is. And we think that should stop. And we particularly think it should stop in the case of companies like 4chan or others who have no presence in Europe, but who are getting regulatory correspondence from Europe asserting jurisdiction over them. And so it does this in two ways. It creates a statutory shield, which says that U.S. courts will not enforce foreign censorship orders. Extradition orders also won't be enforced if they violate the First Amendment. And it creates a private cause of action, a sword, which would allow an American who receives one of these orders to then sue in an American court, specifically a Wyoming court, the version we drafted, for an amount equal to the threatened fine. So if the European Union comes and says, we're going to fine, or if the UK says, we're going to fine you 18 million pounds, which is their statute, or 10% of the global revenue, is the statutory maximum. Actually, I think it might be 6%. That's global revenue in the UK. Maybe it's 10, maybe it's 6. Might be getting the two regimes confused. But they say, listen, we're going to fine you X, right? Okay, fine. I just go to an American court and say, I'd like a judgment for X. And the American court would then, you have a cause of action, you go and retrieve it, you get your damages award. Now, there's some major limitations to that approach at the state level because there's currently federal foreign sovereign immunity doctrine, which immunizes foreign sovereigns from lawsuits in American courts for public policy reasons. U.S. courts are not supposed to sit in judgment of foreign sovereigns, much like they don't enforce the revenue rules and revenue judgments of foreign sovereigns and act as their tax collectors. So what we have tried to do is convince the federal government to make changes at the federal level as well, modifying the Federal Sovereign Immunities Act and the federal, so it's the Federal Foreign Sovereign Immunities Act and the International Organizations Immunities Act for the EU to allow Americans to bring these suits in the event that orders enter the United States, which would threaten them for the free exercise of their constitutional rights. Where we are is at the, I know more than I can say. But what I'll say is I'm optimistic that we'll get something this Congress. But I don't know for sure, but very, very hopeful that we'll get something this Congress. If not, we're virtually certain to get it next Congress. Whether it passes next Congress is another question. That's where we are.
I think more protection of speech is an important thing and obviously within limits, but many judges agree. Let's go back to that Bernstein case, which is the foundational decision in all of this. Judge Patel said there was no meaningful difference between computer language and German or French, and said that like music and mathematical equations, computer language is just that, language. But it's also easier to do more with computers than it is with language. But where does that line sit? Regulated language is a complicated thing, as you and I know. A pamphlet, a painting, a piece of sheet music, a mathematical equation, the Supreme Court has protected all of them because what matters is that a human being is trying to communicate something to another human being. The recurring counterpoint from the crypto wars to Fable 5 is to point at the container and say, this one's different. This one is a munition. This one is a service. This one is an export. And sometimes it is. There's the sculpture example, when if you put a round into the machine gun, it can be fired. There has to be some limiting principle here, but oftentimes court recognize that software is still speech. This is from the Ninth Circuit panel's 1999 majority opinion, written by Judge Betty Fletcher 27 years ago. It sounds like it was written yesterday. Quote, "The availability and use of secure encryption may offer an opportunity to reclaim some portion of the privacy we have lost. Government efforts to control encryption thus may well implicate not only the First Amendment rights of cryptographers intent on pushing the boundaries of their science, just sidebar, same could be true about AI today, sidebar ended, but also the constitutional rights of each of us as potential recipients of encryption's bounty," unquote. And free speech has led to better privacy, healthcare, democracy, economic policy, and I'd say every other field is improved because of it. It's a big reason why our standard of living is 100 times better than those who lived 100 years ago. Now, it's always under threat, but hopefully we'll all remember that the best rules are those you'd be happy to let your enemies enforce. Let's keep talking. Now, I spent over 100 hours on this episode on AI, crypto, and free speech. I think it's a really important subject. If you agree, please just take 30 seconds to share this podcast with at least one person, or better yet, on socials. If you don't have time to, thank you for taking the time to listen this deep in the episode. Make sure you subscribe. At the end of this episode, I'm going to share some of the upcoming episodes, so stick around if you're curious. And thank you to another sponsor, too, of this episode, the Solana Policy Institute. Their mission is educating policymakers on decentralized networks like Solana and the role these networks play in the future of the digital economy. Their ongoing work is an invaluable contribution to the industry at large. A member of that industry is myself, obviously, but also the presenting sponsor of this episode, Altitude. As I mentioned at the top, I got introduced to them because a lawyer I know refers them work. It's unpaid referrals just because it's a better solution for his clients. Altitude employs a simple strategy: solve many hard problems for businesses, specifically those relating to payments. That's why after publicly launching in December of 2025, so at the time I'm recording this, about 7 months ago, they've already processed over $350 million in payments. They have a cashback card. They have all the accounts in one place. I've been really honestly blown away at how it works. If you're interested in learning more, visit altitude.xyz/law, altitude.xyz/law. And what you can do is just book a quick demo with their team, take 10, 15 minutes, understand how it works. If you do that, that'll help you and any clients you have that you want to refer that are looking for a solution like this bypass the waitlist on the site. They'll get white glove service. And if I can, I'll join that demo to help answer any questions that you or your clients might have. It'll help your clients get set up with a new payment system in just a few days. And I know that because I did that myself. Now, this podcast is part of my mission to help people understand the legal layer of emerging tech so that we can live in a world with transparent and well understood rules that are applied fairly to all. I love doing this podcast and I want to continue to keep doing this. You make this possible. So thank you so much again for listening. If you want to subscribe to my free newsletter, which hasn't launched yet, but will in the future, it's called lawofcode.fm. It's not called lawofcode.fm. That's actually the website where you can find it. So lawofcode.fm. It'll be the world's shortest legal newsletter, I promise. Upcoming episodes, if you are interested, include crypto in Canada, how lawyers are AI maxing, meaning getting the most out of AI in their legal practice, some really interesting ideas there, and jurisdiction in the internet age. Now, I can't believe how much fun it is to put these episodes together. It's so much better than watching the World Cup, which I do enjoy. But, some of the games England's played, and I've been cheering for England. My grandfather came from England after World War II. I don't know. They're not a great team. They find a way to win, but I'm not too impressed. Anyways, I hope you enjoyed this podcast. I enjoyed it. See you next time.